Good morning, everyone, and thank you again so much for joining us today. My name is Bill Hufnell, and I am the founder of Bay Point Wealth, and I'm the director of our private client division. And we very much appreciate you joining us today, for which I think is just a really important educational session. We were chatting just beforehand. A lot of times when we do these educational sessions, we may get 20 to 25 people attending. We have 125 participants today, just to give you an indication of how important this subject is. So before I start the presentation, just a few things. One is we're going to run close to 90 minutes. Second is there is an icon you can click to ask questions, and we're going to make this as interactive as possible. So please feel free to ask questions. I'm going to do my best to monitor them, and we'll take breaks throughout the presentation to try to answer some of the questions. If we don't get to your question, we'll do our best to follow up afterwards. And then lastly, we have everybody's email, so we will email out the presentation, I guess sometime next week, along with some other helpful information related to the presentation. So with that, today's presentation is 10 mistakes to avoid when planning for a loved one with special needs. And I was trying to think this morning of some opening remarks, and it occurred to me many years ago, actually 25 years ago, when I started Bay Point Wealth. My very first two clients had circumstances that required special needs, and so it became apparent to me pretty quickly and early in my career that special needs planning is by no means the exception. In fact, it's really quite prevalent. And in fact, even if there's not a special needs planning currently, as you put together your financial planning, your estate plan, you really need to consider the possibility of it happening at some point. And so whenever you put your plan together, special needs to be considered. The other thing that was pretty clear for both these cases in the initial and my two initial plans, both had special needs circumstances, and both were so different. And so there's not anything that you can do in terms of planning that is uniform. Everybody has special needs in terms of their the personal circumstances, and so one plan by no means fits all. And then lastly, emotionally and both from a technical perspective, planning for special needs can really be overwhelming. So finding the right professionals to work with and getting the right resources is critical to having a successful plan. And with that, I'd like to introduce our speaker today, and that's Steve Elville. Steve's an attorney with Elville Associates. He is the founder of the practice and also the managing principal. They're located in Columbia, Maryland. They specialize in estate planning, elder law planning, and of course, special needs planning. Our firm was really quite fortunate to meet Steve and Steve's team several years ago, and I think as it will become pretty clear today, Steve is one of the most compassionate, caring, and just all-around nice guys you'll ever meet. And not to mention, he also happens to be an expert in special needs planning. So good morning, Steve. Very nice to see you, and thank you for taking the time to present to us today.
Thank you, Bill, and good morning, everyone. And it's my great privilege to be with you today. And I want to thank Bill and Bay Point Wealth for having me help educate again. And Bill and I have worked together in the past. And I want to thank Amy as well for all the work she did this morning to organize this, and my community relations director and longtime friend, Jeff Stauffer. And it has just been not only my privilege to be with you this morning so far, but also over the years, I've been very privileged to work in special needs and special needs planning. And one of the things we're going to do is, as I share my screen with you now and start to look at the presentation we're going to actually work through today, and if you'll bear with me just a second, and I'll get my actual slideshow going. And Bill, hopefully you can see that.
It looks fine, Steve. Thank you very much.
Thank you. One of the things that Bill had specifically asked me to do is to really get down to kind of the nitty-gritty of the mistakes people make in special needs planning. And so often we give workshops about the general overview of special needs planning, but Bill specifically said, Steve, let's get right into what the mistakes are that people need to be aware of that they can make. So we're going to make this very broad and informative. We're going to go through this informally, actually, however. We're going to give you the opportunity to ask questions, and we're going to stop at certain points throughout the presentation. And I would like you to look at this workshop as, I would just say, a mini master class on supplemental needs trusts and special needs planning that we're going to go through. But not only just the general overview again, but a mini master class on how to avoid mistakes. And there are many different types of circumstances, as Bill indicated. And what I want you to do today is not to be overwhelmed by this information, which is very easy to do. It's very easy to get overwhelmed, but you're going to have this PowerPoint, and Bill's going to make sure that you have that. And you can use this as a resource and a reference point. And I would like you to walk away from this, not overwhelmed, but I'd like you to walk away with this and say to yourself, I've got something substantive here that I can use as I think through my own situation. And I know some of you are parents with loved ones with special needs. Some of you are family members of loved ones with special needs, other family members and friends, and maybe even advocates. So I just want you to relax, know that you can ask questions as we go through. Don't become overwhelmed. We're going to not only educate you this morning, but we want to give you a path forward to either have existing documents reviewed or to be able to engage in a counseling process to be able to understand what are the goals and purposes of special needs planning in your own situation. So with that said, I thank Bill and Bay Point Wealth again, and we're going to get started. Now, of course, everything we discussed this morning can't be considered to be legal advice, but we definitely want to, at a very high level, provide general information and to be able to answer questions as generally and sometimes as specifically as we can without it being legal advice, just because we can't meet face-to-face today through this virtual mechanism. So today we're going to talk about the 10 biggest mistakes in special needs planning and how you can recognize them. And that's a big issue. How do I recognize when I'm making a mistake? And that's one of the biggest issues in today's world, right? Everything is moving so quickly. There are so many changes politically, in the legal world, socially. How do we avoid mistakes and recognize them? And what do we do next to be able to do that? Now, how planning mistakes actually occur. Okay, this is part of being able to recognize these problems and what you can do to avoid them. And what proper special needs planning actually looks like. So you can actually recognize that. You can actually know what is the difference between good planning and bad planning. And one of the things that Bill and I have discussed before is the fact that it's quite shocking, but in the special needs world and of elder law and the practice of estate planning and special needs and elder law, we actually see so many mistakes. We see trusts that are supposed to be special needs trusts. The person who implemented that trust did not know any better, and that trust is not what it's supposed to be. So we need to be able to recognize what we have in front of us and whether that's problematic as much as possible. And how to maintain a special needs plan throughout your lifetime. So one of the things we want to emphasize, and I know Bay Point Wealth is a big believer in education. That's why we're doing this today. And it's not the first time I've educated with Bill. The idea with planning, whether it is tax planning, financial planning, special needs planning, estate planning, charitable planning, whatever the planning is, we need to have a goal. We need to have a purpose. And so you may not understand what that purpose is today, other than maybe vaguely understand it. And we want to help you in the planning process to formulate what those goals and purposes are. But after we do that and you get the planning in place, what we want to do is have a system throughout the rest of your lifetime to follow up on that planning, to update that planning, to be able to say, well, these family members, their situations have changed. We have different phone numbers and addresses and different health situations in the family. And That way, you can actually look at planning and not be so stressed, let's say, because so many of us feel like when we're doing planning, especially planning as important as special needs planning, that we have to get it perfect. And of course, we want it to be as perfect as possible, but we can't always have it perfect over the long term because of all of the changes that occur in the world and in our lives. So if we maintain planning, we can make sure that it actually is updated over time and will actually work the way that we want. And then, of course, we're going to take the questions and answers and provide answers as much as we can, as I mentioned. Okay, with that said, we're going to get right into the material. And again, thank you for being here. So the number one mistake that I see in special needs planning, arguably, is the reliance on self-help methods of planning. Now, what am I talking about? Well, I'm going to show you some bullet points here in just a second. But this number one problem, I just saw this about 3 or 4 days ago. I was talking to a former client, a past client, and this person is a wonderful parent of a special needs child, but they were relying on some of the methods that I'm getting ready to show you, and you'll see fairly quickly why these are not good ideas. Now, as I get right into this number one problem bullet point list here, remember that we are going to get to the idea of what does represent the proper planning. So we're first starting out here on kind of a negative footing by saying, these are the things we need to recognize right away that are just not going to work well. So an outright inheritance, let's say that we pass away and we leave a direct outright inheritance. That inheritance is going from you or a loved one from point A to point B. And point B is our loved one with special needs. Well, that outright inheritance is one of the big problems. That person, if they are on means-tested benefits, which we're going to talk about, that person is going to lose their means-tested benefits, whether that is SSI, Supplemental Security Income, and Medicaid, or a waiver program, which many of you are understanding what that is already, and some of you may not, but a waiver program that provides lots of benefits to the loved one throughout their lifetime. These kinds of means-tested benefits would be lost. So we don't want to leave an outright inheritance, whether we intentionally did it, which probably is not the case, or unintentionally did it. Now, the second one has to do with a comment that I just made a few minutes ago. Leaving assets in a trust that looks like a special needs trust, or the innocent person who was creating that trust thought or was told this really is the proper special needs trust, but it's actually something we would call a non-qualifying trust. So in the interest of time, I'm just going to describe this fairly quickly. In the world of special needs, the special needs trust is called a discretionary trust. And do not worry if you don't remember all of this. But the discretionary trust is the very idea of the special needs trust. And this is a trust where the trust holds the money of the beneficiary, and that money is exempt. It is exempt for public benefit purposes because under the Maryland Discretionary Trust Act, that discretionary trust is exempt. Now, imagine that you have a child or loved one with no special needs. This is a healthy person. Well, that trust that might be left for that person, we would call that a support trust, not a discretionary trust. That support trust is something we might say is for that person's health, education, maintenance, and support. That kind of trust will destroy or eliminate benefits for the loved one with special needs who is on means-tested benefits. Remember, SSI, the Medicaid system, the waiver system, those types of means-tested benefits. So if we leave assets into the wrong kind of trust, that's going to cause a loss of benefits. Now, my dear client from the other day was leaving assets in the third way here. They were leaving assets to another child for the benefit of their loved one with special needs. Now, of course, their intention was that the money go from themselves, whether it's life insurance policy, retirement plan, from a will or a trust. to the non-disabled child who is designated to take care of the disabled child. Now, this is where the problem is that I'm really trying to illustrate here. That is a recipe for disaster, and it does not need to happen, and it should not happen. And just to be clear, leaving assets from yourself or someone else in the family to someone else in the family for the purpose of taking care of the special needs child. So what could happen there? And in this example, which is so common, this person is planning until we spoke the other day, they were planning to leave assets to a child, and that sibling was going to take care of the other disabled sibling. Well, the problem with that is anytime that we leave assets to someone, they could lose those assets to a creditor. So let's say that sibling receives the money, whatever that may be, and now they have creditors. Their assets that are in their own name are subject to the claims of creditors. So that's not a good plan, because the money designated for the disabled loved one could be lost to the claims of the other sibling's creditor. Now, what happens if that sibling were to die? And now they inadvertently, not intentionally, they left that money either through their will, or if they have no will, they still left that money to other family members, their own children. And now the loved one with disabilities has no money to take care of them. What if that sibling decides down the road they don't want to take on the responsibility anymore? We see this many times. Many of you have family members and children who are very committed to your loved one with disabilities, and they would never dream of kind of losing interest in taking care of them. And then there are many families where a sibling or siblings just will not, it's just not in their character or personality or in their future plans to take care of the loved one with disability. So we have to be very careful that we understand that later in life, that sibling may not, because of their own situation, be able to take care of the loved one with disabilities. Or the money could be lost in a divorce. So let's say that sibling receives the money. It was all well-intentioned, but they somehow commingled that money with their spouse, and it ends up in a divorce. And now at least half of that money is separable or subject to separation in a divorce. So these are things they're fundamental things. I don't think you're going to do this, but I just want to point out, and Bill was very adamant that I point out some of the most common mistakes, and this is one of them. The last thing I might say, even though it's not in the bullet point here, is that sibling could have a tax obligation. They could owe Uncle Sam taxes, and Uncle Sam now levies their account, and the money that was intended for your disabled child is now lost to Uncle Sam or the Comptroller of Maryland. So with that said, we don't want to make those mistakes. And now we're going to move on to the next and the second of what I would call the most common mistakes. So this mistake has to do with not having a comprehensive personal estate plan. Now, this is going to have various aspects that we're going to spend a few minutes on here, but it also has to do with coordinating with other family members. So let's talk about this concept. So if you take care of yourself first, and I'm going to show you what I mean by that. If you provide the basic estate plan for yourself first, wills, powers of attorney, advanced medical directives, or a substitute for a will, a revocable living trust, powers of attorney, advanced medical directives, you are first setting the stage for lots of things. Flexibility in your planning, future planning for your disabled or non-disabled loved ones, planning for spouses. But look at the second part of this number two mistake. Integrating or including or other family members. So let's say you do the proper planning. You are actually one of those people and families who actually do the proper planning. But now there are other family members, such as grandparents or siblings or other extended family members that wish to leave assets for the loved one with disabilities. If we don't coordinate properly with those people, then those well-intentioned loved ones may leave assets directly to your disabled child or in ways that could really hurt the child, and other measures would have to be taken. So we want to avoid those things. Let's get right into what I'm talking about. Those of you on the call here this morning that have estate plans, I want to salute you, because most people in this country have no estate plan. Somewhere between 55 and 62% of people in the United States have no estate plan. But getting right to the basic structure, here you see a will-based plan. Will is the driving force. This is the driving force of the planning, but we have documents on either side of the will: financial powers of attorney, advanced medical directives, okay? This is a very solid estate plan, and don't let anyone tell you that it isn't. This plan in and of itself is sufficient for most people. Now let's go to another illustration as I go to the next slide, and I'm going to skip to the revocable trust slide. Some of you may have a revocable trust, or you're thinking about a revocable living trust, as we would call it. If you were to say, Steve, how do I get a basic estate plan in place so that I can do special needs planning? We're going to be looking at a will structure or a revocable trust structure. The revocable trust is nothing more than a substitute for a will. It seems like a lot, it seems complicated, but it's nothing more than a substitute or an alternative to a will. So the revocable trust has some steps that have to be taken to make it work. The will has some steps that it has to be taken to make it work the proper way. But these are the structures that I want you to get in your mind as you start thinking about your basic estate plan. Let's go back to the will very quickly. And we want to understand that wills, by their very nature, are subject to the probate process. Now, that's not what we're focused on today, but we just need to know that as part of special needs planning, possibly you might conclude that you don't want your plan to go through probate. Not that probate is not a process that can be overcome. It's not a terrible process necessarily. It's just a process of proving the will to be valid. So those of you who have wills, or you're thinking about getting wills, this may not be a big issue to you, the issue of probate. And remember that we can have probate with a will, or we could have probate if you have no will. And just as an educational piece, and then we're going to move on, what goes through probate are these assets. Assets that are in your sole name, if you're writing this down, assets that are in your sole name with no joint owner. They have no joint owner and no beneficiary. So if you have assets that are in your sole name with no joint owner and no beneficiary, those assets are going to go through probate at your death. Again, the more important thing for today is not whether you have probate. The most important thing is that you have a plan. And so this will plan, I just want to give you some background on it. You see that it does two things. The will is the driving force. The powers of attorney and advanced directives are the what happens during life documents. These are the ancillary documents. These are the incapacity planning documents. So if you have a piece of paper or a tablet in front of you, I want you to look at this and draw a circle, and I want you to say that circle is my will, and right under my will is a straight line, and that straight line is my date of, that is possibly my date of death, but what I'm trying to illustrate here is that straight line is the difference between what happens at death with my will, but what happens during life. The powers of attorney and advanced directives are what happens during life. And in just a few moments, I'm going to show you more about powers of attorney, and I'm going to ask you some specific questions about your own power of attorney situation and whether you have one, and I'm going to give you a fact that you might find somewhat surprising. So let's go now back to the revocable trust plan. With the revocable trust plan, remember the most important thing is whether you have a plan. That's the most important thing. The revocable trust is the driving force in this illustration. But notice that the powers of attorney and advance directives are still very important. They are still part of this plan for incapacity planning. The revocable trust is, again, nothing more than a substitute for a will. It doesn't avoid creditors. It doesn't avoid taxes. It is primarily a probate avoidance approach. You can do special needs planning with a will-based plan. You can do special needs planning with a revocable trust plan. It's all going to be dependent on the types of assets that you have, your goals, and what we're really trying to accomplish. Okay, let's now go back to those pesky incapacity planning documents. So if I were to show you this graphic, and I were to try to explain this in a very brief nutshell, what you are doing here for yourself, and that's what's very important, you're making sure that you are planning for your own potential incapacity so that you can avoid guardianship of yourself. Now, why am I putting so much emphasis on you this morning instead of just on the special needs planning so far? Well, what document do you think is arguably the most important document from a legal standpoint in estate planning? And I'm going to repeat that question. What is the most important document from, let's say, someone like my perspective, someone like me as an attorney? What do really well-versed attorneys think is the most important document? Well, I'll give you the answer. The most important document, arguably, in estate planning is the financial power of attorney. So whether you have a will-based plan or a revocable trust-based plan, your financial power of attorney is arguably the most important of all the documents. And what does this have to do with special needs planning? Well, not only to get your basic planning in place, but here's my argument. If you were incapacitated, God forbid, what would your agent do for you under a financial power of attorney? Well, they would pay your bills, take care of you. Pay your bills, take care of any person such as a spouse if you're married. But also pay your bills, take care of your spouse and any person who is dependent on you. Now, I want you to think about that. That's a very broad statement. So you can probably start to see that the financial power of attorney is a document that you can provide a lot of flexibility. And I strongly recommend, depending on your family situation, that you would provide a lot of flexibility in your planning down the road in the event that you were incapacitated. I told Bill that about 8 months ago, I had a 105-year-old man in my conference room, and he was there with his 94-year-old wife, and we were updating their estate planning. So you see, people are living a long time today, and we want to think in terms of long-term flexibility, in my opinion, although every situation is different. And of course, many people feel the advanced medical directive is the most important of all documents for them due to their health situation. But from a legal perspective, the financial power of attorney, and in special needs planning, the financial power of attorney is very important. Now, we're going to talk a little bit more about this in the presentation, probably if we have time. But remember, for higher capacity or higher functioning beneficiaries with special needs or disabilities, those individuals may also sign their own powers of attorney and advance directive and avoid guardianship of themselves as an adult. So we want to avoid guardianship of ourselves as non-disabled people who are planning for our loved ones with disabilities, but we also want to avoid guardianship wherever we can for our loved one with disabilities. Now, you may have noticed, as you see this next slide, the statutory power of attorney in Maryland. You may notice as I go back to this slide that in this power of attorney circle, we have the power of attorney for the state of Maryland, the statutory form, as well as a different power of attorney, the general power of attorney. We don't have time to go into all of these bullet points today, but I wanted to give you this information to let you know that Maryland now, as of 2010, a long time ago, Maryland has its own statutory power of attorney. Again, As an elder law attorney, I'm very focused on powers of attorney because I know, and many of you may know, that this is what provides that special flexibility for our family if we become incapacitated, heaven forbid. The Maryland form has its strengths. It's enforceable by law. And there are two types, which we don't have time to go into today. But what I want you to know is that the basic statutory powers are not enough. They are good. They are enforceable by law. This helps Maryland get up to speed with other places like New York, Delaware, West Virginia, DC that have statutory forms. But as part of your planning that we want to make sure actually works, if you become incapacitated and down the road when we die, we want to make sure that we understand that we need to have flexibility in these powers of attorney. And many times this will involve the use of two powers of attorney that live together and work together. So we don't have time to cover all aspects of this, but I want to give you the basics of why this is so. Okay, as we kind of round out this portion of talking about our own estate planning, healthcare decision-making. So this is something that we want to not skip over for our own estate planning, making sure that we take care of ourselves as we set the stage for taking care of our loved one with disabilities. And in the interest of time, I will just say the advanced medical directive can be and should be customized. You don't have to, but we strongly recommend that you customize these forms. And for your loved one with disabilities, if they are a person of higher capacity that can actually execute estate planning documents, this is something that is very important for them because they are waiving HIPAA. They are actually waiving the HIPAA laws so that once they are an adult, they are clearing the way for you to be able to make their healthcare decisions. And not only that, but to get their medical records, which is protected by HIPAA. Okay, Bill, I'm going to just take a second here and stop to see if anyone has any questions. I know that's quite a lot for the first 20 or 30 minutes. And we'll answer questions if there are any, and if not, we'll move on.
Sounds good, Steve. Let me just check the queue. No questions yet. I did have one thing I was going to bring up. I think it was on your earlier slide, and we have seen in our planning sometimes confusion around the most form. And I didn't know if that was coming up or if you could just briefly mention that, particularly with respect to comparing it to the Advanced Healthcare Directive.
Thank you, Bill. So appreciate that. So we didn't include a most slide today, but here's something that's important for you to know. And it's important not only for yourself as an individual, but for your loved one with disabilities and their healthcare decision-making. So in 2013 and 2014, Maryland implemented something called the Medical Order for Life-Sustaining Treatment. That's a mouthful. The Medical Order for Life-Sustaining Treatment, MOLST. And some states call this POST, the Provider or Physician's Order for Life-Sustaining Treatment. Now, what is this? Well, in a nutshell, the MOLST form is required by law in Maryland. If I left here today and, God forbid, ended up in a facility, and ultimately, let's say I ended up in an assisted living, I would have to have a MOLST form completed. And a doctor completes this form, Bill, or a nurse practitioner. And that MOLST form is technical. It relates to my current healthcare situation. And it is really the driving force. It's a medical order. And as of a couple of years ago, Maryland was the only state, other than 3 other states, Maryland was one of 4 states to require the MOLST form. So what I recommend is as you are making your healthcare decisions, and maybe your loved one with disabilities is completing an advanced medical directive, we want to be aware that the advanced medical directive is signed by you. It is very general in nature. It has to do with the future. What happens to me? What happens to my healthcare decisions if I have a problem in the future? But it is not a MOLST form. So does that mean that the advanced directive is not important? And the answer is no, because in the advanced directive, we are naming our agents, We are giving a general overview of our wishes and our end-of-life decisions. This is still extremely important, and it avoids guardianship because we have appointed agents. But we have to be aware, and we want to educate our fiduciaries, our healthcare agents, that this thing called a MOLST form actually exists, and we don't want these people to not know about this. They will not be informed unless we inform them. And in some cases, you may give them authority that they can actually change your MOLST form. Now, this is something that I'm glad Bill brought up, but it's going to worry some of you. It's going to worry you. You can actually get more information about this on the Attorney General's website of all places for marylandattorneygeneral.gov. But if anyone has questions about MOLST, Bill and I and my assistant Jeff can actually circle back with you to get you some MOLST information. It is not something to worry about. It is something just to know about and make sure that our agents are aware of. So thanks for bringing that up, Bill.
Yeah, and Steve, we have two questions.
Excellent. Excellent.
One has to do with purchasing a vehicle and the related titling to that. The question is, do you put a motor vehicle into a revocable trust?
That's a great question. You can put a motor vehicle in a revocable trust. You could also put a motor vehicle in a special needs trust. I just want to throw that out there. But for your question about the revocable trust, you would need to notify your auto insurance carrier that you made the trust the owner of your vehicle. So you would need to do that. And number two, I would say you don't need to do that anymore unless you really want to, because the MVA will allow you to make your vehicle transferable on death to a beneficiary. So you no longer need to do that, but you can do that if you want to.
Yeah, thank you, Stephen. I've seen the form before. You can get it on the MVA site. There's a beneficiary designation form for a motor vehicle. The second question is, I have guardianship of my son who is 22 with special needs. He only receives payments from Social Security, which is under $1,500. I'm trying to determine how much it would cost broadly to see if we have funds to even work on some of these options. My husband and I are not in a financial position to pay for it out of pocket.
Well, thank you for that question and for being so honest about it. So first of all, for our firm, we don't charge for initial consultations about special needs planning and estate planning in general. So don't worry about that. If you need advice, we are here to help you get that advice. And the second part of your question is just my firm, Elville and Associates, our good fortune, I should say, to be able to work with the special needs community, and we've been very, very fortunate over many years. So our policy is that if someone, maybe such as yourself, is of limited means, we still will make sure that the plan gets implemented. So don't let that stop you, because we work with families with loved ones with special needs of all kinds. We have older parents, younger parents, young special needs children, older adult children with special needs, grandparents that come in to do planning for their loved ones. So don't let that stop you. We're here to be a resource for you.
Excellent. Thank you.
Thank you. Okay, the third bullet point, and in the interest of time, I'm going to move forward now, is the failure to understand the types of special needs trusts. Now, remember, my first point was that many times we're not even looking at a special needs trust. We're actually looking at a general needs trust that we think is a special needs trust. Now, that's a problem in and of itself. Here, I'm talking about understanding the types of special needs trusts themselves. So let's look at this chart. The one that I want you to focus on is the third-party trust. Now, let me explain this to you. There are two concepts. One is the third-party trust, and I don't want you to think this is too complicated. And the other one is the first-party trust. Now, the third-party trust is the bread and butter of special needs planning. This is the one that I want you to focus on today. And what am I talking about when I say a third-party trust? Well, I want to explain this very simply. You passed away, let's say, and you had a will or a trust. Your assets are coming from that will or trust directly from that will or trust to the third party trust for your special needs loved one. That is going from point A straight to point B into the third party trust. It is a third party, yourself, who is leaving money for the benefit of that loved one. Or let's say it was a life insurance policy or an IRA. Those assets are going into that third party trust from you, the third party, or from a relative of yours, a grandparent, or a parent of yours, a grandparent of the special needs child. It's going from that person straight to the trust. That is the third party trust. And because the money never went to the loved one with disabilities, they are deemed to never be the owner. So that is what we want to focus on. So the source of funds can come from anyone except the beneficiary themselves. So that's an important point. That's the third party concept. Anyone can establish this except the beneficiary. Now, look at this right side of the first column there. It says what happens on the death of the beneficiary. This is an important thing. There is no payback to the state of Maryland. So the third party trust, the bread and butter of special needs planning, has no payback to the state of Maryland because it is third party money. All states recognize that a third party can establish a trust for the benefit of a disabled loved one and leave money to that trust, and there is no payback. At the death of the loved one with disabilities, hopefully many years later, that money can go to whoever you, the grantor of the trust, want it to go to. Now look at the second and third columns. We're not going to spend a whole lot of time on the third one. The second column is a first party trust. So under the United States Code, in section or article 42 of the United States Code, there is a section that is talking about special needs planning. And we call this a D4A trust. This is 1396P D4A under the 42 United States Code. And just to let you know that that's kind of where that is if you want to look at that. But this is for someone who did not have the correct planning, meaning the money came straight to them. It's a first party trust. Why is it a first party trust? Because the disabled person themselves has the money. And remember, when they have the money, it is going to disqualify them from means tested benefits. So the first party trust is not what we want if we're doing basic planning. However, sometimes the first party trust cannot be avoided. Let's say your loved one or a person with disabilities, they were injured in a car accident or a train accident or in a birth injury, or they've been awarded some kind of award or they've inherited money. One of those extended family members left money to the person and they shouldn't have. Well, now if that person is under 65, that money can be taken out of their name and put into a first party trust. Now, this involves a little bit of a process, and you'll notice that this trust can be established by a parent, grandparent, guardian, court, or even under the new Obama law that came into effect, it can even be established by the disabled person themselves if they have the capacity to do so. At that person's death, if the state of Maryland or any other state has paid for that person's benefits, that trust has to be paid back to the state. And then other remainder beneficiaries can actually participate in being beneficiaries after the state is paid back. So ideally, we want the third party trust to be part of your estate plan. The first party trust is something that we would use if we had to. And in some cases, we would go ahead and establish a first party trust along with the third party trust just to be sure that we have it in place. But it is not something that you have to do unless your loved one with disabilities actually has money or funds in their own name. So the third party trust is really what we want to focus on. The pooled trust is a trust that even if we are over age 65, we can put money from the disabled person on people. So all of those options are called special needs trusts. But for our purposes now, we are going to go to the next slide, And we're just going to keep talking about this third-party trust for just a few minutes. So this is the trust that we normally would use. This trust can be inside of the will. It can be inside of a revocable trust. It can live right inside of there. That is the least expensive way of doing this. This is maybe the most cost-effective way of doing it. Or the trust can stand on its own. And this is really the preferred method for various reasons. And we'll talk about this in just a minute. So again, this is called a third-party trust because it's established with the money of someone other than the disabled beneficiary. And again, the beneficiary doesn't create this trust, someone else does. The trust does not hold any of the beneficiary's own money, and the beneficiary cannot be the trustee. And remember, we call this a discretionary trust. All right. Now, again, just drilling down now in some of the things I've already said to try to bring these points out. This is the most common trust. We many times now will call this a supplemental needs trust. So what I want you to be thinking about when you're thinking about special needs trust, I want you to think of the third-party trust as a supplemental needs trust. And I want you to think of the first-party trust as a special needs trust. These are just terminologies that lawyers use. There are no payback requirements. It can be revocable. Bill mentioned a question that someone had about a revocable trust. A special needs trust, or supplemental needs trust, I should say, could be, and many times today is drafted as a revocable trust. And this provides more flexibility during your lifetime in most cases. Now, this is a good example of a modern supplemental needs trust, okay? Let's just take a look at this, and I want you to think of that circle as the trust itself. And you'll notice we have trustees. We're going to talk more about trustee selection today. You'll notice a special fiduciary called a trust protector. We're going to talk more about that. A modern trust like this has provisions for funding Maryland ABLE, an ABLE account. Many of you have ABLE accounts for your disabled children. Many of you are thinking about it. And for those of you who didn't know, the age for disability to have occurred to qualify for an ABLE account will be increasing from age 26 to 46 in 2025. So that's very good news for many people. A good supplemental needs trust is going to have an advocate provision. The trust is actually going to speak to the trustee. The trust is not going to just be legalese. The trust is going to, in the modern way of thinking, talk to the trustee and remind them that they can hire professionals like advocates. A memorandum of intent. Bill and I talked about this yesterday and the day before. This is a document that you as a family or you as a parent can customize to make your trust more personal to your loved one. There are millions of trusts out there, millions, and most of them have no memorandum of intent. So we're going to talk about that today a little bit later. A trust advisory committee. This is a flexibility mechanism if your loved one, especially if your loved one has needs that are more significant over time, or even mental health issues. And then there are special requirements or considerations, I should say, for retirement plans. Under the Secure Act, which many of you may know about, your loved one with disabilities most of the time is going to be exempt from the onerous laws of the Secure Act, which really accelerate the taxation of IRAs. So we don't want that to happen. We want your loved one with disabilities, we want to recognize that they are exempt from the Secure Act, meaning they can stretch out their retirement plan benefits. They do not have to take those benefits in 10 years. And also the trust for that person, whether they have special needs or chronic illness, that trust, that supplemental needs trust, is also exempt.
And Steve,
Now, go right ahead, Bill.
Excuse me, I'm sorry, just real quickly, because I think we have a question that's sort of relevant to the slide you were just on.
Yes.
It has to do with the ABLE account, and to what extent, if the disabled person has an ABLE account, does it impact any other planning particularly, I think, with respect to the context of like a third-party trust.
Yes, that's a great question. Thank you for that. So the Maryland Able account, of course, is not a trust account. It's a tax advantaged account and so forth, and it enhances the life of the person with disabilities. The only kind of limitation I can think of is, as part of the planning, we want to make sure that if your loved one with disabilities is an SSI recipient, we want to make sure that we recognize that if they are on SSI, then they cannot have more than $100,000 accumulatively in their ABLE account, because that's the cutoff point when they will lose their SSI at that point. So a person on SSDI, Social Security Disability, is not going to be limited by that 100,000, but a person on SSI is. But that's the only limitation that I can think of. That's a great question.
And just real quick, we had Kelly Nelson from the Maryland Able program speak to our group just a few weeks ago. Did an excellent job, and we will include in the follow-up a link to the Maryland Able plan for everybody.
Excellent. Kelly is really a great resource for anybody who's on this call this morning. So thank you, Bill. And remember that a supplemental needs trust can pay for basically anything, okay, for the benefit of the beneficiary. Now, of course, there are practical limits, like someone could not use a supplemental needs trust for distributions for gambling and other things like that. But a supplemental needs trust does not affect the beneficiary's government benefits. And I want you to think in terms of when a trustee is distributing from a trust, any trust, but especially a supplemental needs trust, remember that a trustee can make payments to the beneficiary or for the benefit of the beneficiary. So 99% of the time, it's always going to be that the trustee is paying something for the benefit of the beneficiary. So a very, very quick example of this is your loved one needs an iPad or a computer. Well, the trustee can do one of two things. They can give the person $700 or $800 or $2,000 to buy a computer, or they can simply buy the computer for the benefit of the person. And so the reason that's so important, and that simple concept can really make sure that your loved one never is disqualified from means tested benefits, especially if they are on SSI. So we want to make sure that the trustee is educated and understands what they're doing so they don't hurt the person with disabilities. One book that I would recommend to everyone, if you're writing this down, is a book by a fellow named Kevin Urbash. Urbatsch. Urbatsch. Kevin Urbash. He is the past president of the National Academy of Special Needs Planners. He is in California, but I don't think that's going to affect your decision to read his book. So his book is How to Administer the California Special Needs Trust. Now, I want you to ignore the word California because it's a wonderful book and it will educate you and educate your trustee, your fiduciary, about these important things. Many people have this issue. How much should I fund into the special needs trust, or what I will now call the supplemental needs trust? Well, thank goodness for those of you on this webinar who are already clients of Bay Point Wealth. You should utilize Bay Point and Bill and all of their resources and their experience about how much to fund into such a trust. Of course, some of this has to do with the counseling discussion about special needs planning itself. Do we treat all the kids equally? What are the pros and cons of that? But also, what kind of assets are we going to fund? Are we going to fund our retirement assets mostly because those are exempt under the Secure Act? Or do we not have sufficient funds, and are we going to need life insurance as a funding tool? You see, in a perfect world, all families with a loved one with disabilities would fund the trust immediately. They would use permanent life insurance and those types of vehicles in a perfect world. But not everybody can do that or does do that.
And Steve, if I could, while you're doing that, another question did come in. are there limitations on what the third party trust can pay for?
Well, it's a wonderful question. And the answer is, practically speaking, there are no limitations because the third party trust is very broad in what it can pay for. Basically anything for the benefit of the beneficiary is fine. Anything that's really for their general benefit. Now, the first party trust is more strictly regulated, okay? And this is the one that where we have to provide a report to the state of Maryland every year, and it's regulated and monitored by the state of Maryland, and there's a payback. But there's, even with that trust, there's quite a few things that it can be used for without much limitation. And I'm happy, Bill, to provide a list of what trusts can pay for generally, and Jeff can get that out to everyone.
Sure.
So that's a great question. Okay, now let's talk about first party trusts again. These are when someone receives an inheritance, they have been injured. These trusts have their purpose, and we just need to know it's there. The most common thing to avoid, of course, is that whole issue of making sure that we're coordinating with extended family members so that they're not inadvertently leaving money outright to a special needs loved one. But if that does happen, you should not panic because there are ways of dealing with that, and it will be resolved, even though it might temporarily knock your loved one off of their means-tested benefits. It would be resolved. So do not worry if that happens, but we want to try to avoid it if we can. And again, this happens under various circumstances where there's personal injury awards, an inheritance, or a gift, but it can usually be resolved fairly quickly. And compared to the old days when we used to have to wait months to get a first party trust approved, that is not the case anymore. And they're relatively quickly approved so that we can fix problems if that happens. Now let's talk about poor trustee selection for just a moment. Bill, I'm just trying to do something here on my screen so that I can see my own screen a little bit better. There we go.
Yeah, sure. While you do that, I have one other question did come
Go
in.
right ahead.
You had mentioned the reporting requirements for the first party trust. Are there any reporting requirements required for a third party trust?
That's a wonderful question, and the answer is no, because there's no monitoring of the third party trust. And in my opinion, the local departments of social services and so forth have no right to really monitor these trusts. Now, every once in a while, someone from the local Department of Social Services or a supporting organization will want to take a look at a trust, thinking that it's a first party trust, but it's really not. It's a third party trust. So we usually get that resolved fairly quickly. There are sometimes misunderstandings, but you do not have to report now trustees should keep accountings, and trustees should of course be very responsible, but there is no reporting on that. With that said, when we actually fund a supplemental needs trust, a third party trust, a good idea is to send a certified copy with a green return receipt to Social Security, even though they're really not scrutinizing these trusts. It's just a best practice that when and if we ever fund these trusts during our lives, we want to send a copy to Social Security, and we're usually never going to hear from them, but just as a due diligence, it's always a good idea. And that way we have a green card that shows they signed for it. And if they ever do make issues about it, which I can't conceive that happening, but if they ever make issues of it, we can show that they were notified years earlier. Okay, in the interest of time now, I'm going to keep going. Poor trustee selection. This is the fourth major thing. And as we look at these individuals here, I always like to tease Jeff, these people are perfect trustees, and that's what we want to shoot for. These particular individuals, they advocate for the loved one with disabilities. They have their best interest in mind. They understand public benefits, and what do? They promote quality of life and independence. And at the same time, look at these concentric circles. These people understand how to keep records. They understand the importance of that, and they hire professionals if they can't do it themselves. For example, Bill, I've seen actually some trustees trying to invest assets on their own. They're non-professionals, and that's just not a good way of doing it. A good trustee understands that they have the ability and the responsibility to hire professionals to do the advising and the investment. They keep up with their statutory duties. There are duties of giving notice and giving information, even to a disabled beneficiary. They're entitled to information. And again, on the financial side, they understand taxes, they understand investments, even though they may not be doing it and should not be doing it themselves. The basic thrust here is that they understand that they can and should hire professionals. All right. Now, the role of the trustee, and I continue to just manipulate my screen here, the role of the trustee is to administer the trust, follow its terms, keep accurate records, account to the beneficiary, okay, and to make distributions, remember, either to the beneficiary or for the benefit of the beneficiary. Communicate, ensure tax filings are complete, manage assets, to avoid certain types of income taxation for trusts. Now, this is a broad topic. Now, we do an entire workshop on this, how to choose trustees, and we would be happy to send you that link as well. This is arguably one of the hottest and best, most important topics in estate planning and special needs planning in the world today. Who is going to administer our trust? Should it be a relative? Should it be an independent person? I was at the Heckerling conference recently in January in Florida, which is the big estate planning conference in the United States. And the elder law attorneys there giving a presentation on special needs, a certified elder law attorney with a special needs child of her own, argued strongly that family members perhaps should not be trustees of trusts, but rather they should maybe be advocates for the person and not necessarily being the trustee. But this is going to depend on every family situation. In many families, a family member will be the trustee. But this was the point of view of someone who was a certified elder law attorney, and I think is a strong point that she's making. Trusts, why are trustees being selected such an important topic? Well, trusts can now last forever. Maryland is very liberal on how long trusts can last. Trusts can be ported from one state to another. Neighboring states can be in competition for trusts. For example, our neighbors in Delaware, there are very advanced trust laws. Not that we would use a Delaware trust for special needs planning, but just the point I'm trying to make here is that various states have various laws about trusts. And depending on where your child with disabilities might live someday, this could affect the trust. And so trusts need to be flexible. Trusts can be actually decanted, and I don't want to be too confusing, but what I'm trying to say is that some of you, when you're doing planning for special needs, some of you, you might have a child whose disabilities are rather borderline, and you might be concerned about, is special needs planning really the right approach? So I just want to assure you that if we build flexibility into the plan, we can plan for such things, that maybe someday my loved one will not have disabilities and not need a special needs trust. And could the trust be changed in the future? This is called decanting. And remember, when we're thinking about trustees, trustees can refuse to serve. We have to think very carefully about who the trustees will be, and have we covered our bases as far as successor trustees? So this is part of the conversation, and building in flexibility and updating the planning over the years to make sure that if someone's not an appropriate trustee, that they are removed. And of course, we're always planning for changing circumstances. A good example of that is the Secure Act. The Secure Act came along in 2020 and has had a major effect on special needs planning. Now, when you select a trustee, this might be easy. This might be, well, I know exactly who this is going to be. It's going to be my child or sibling. But as I mentioned earlier, there's an entire discussion about interested trustees, meaning family members, versus independent trustees, okay? And this is all pretty much discussed during the design process. And there could be conflicts between interested trustees. You know, as many of you can imagine, a sibling who is a trustee for another sibling's trust. And in some special needs situations, that's going to be fine. And in others, it's not. And corporate trustees, should we use a trustee that is what we might call a corporate versus an individual trustee that's independent, a friend or family member who is not really, who's more than arm's length. So there are advantages and disadvantages, of course, for every situation. Like Bill said in the beginning, no special needs situation is the same. And trust protector considerations. So we're going to talk about the trust protector in just a moment, but the trust protector is a flexibility mechanism. So we recognize that trustee selection is something that might be challenging for you. It might not be, but it is something that needs to be fleshed out in a discussion or many discussions about what is best and how do we plan for flexibility in the future for trustees.
And Steve, we do have a question.
Yes, go right ahead.
This is, how do you find professionals to administer trust, and what is the cost range, and how is it typically paid for?
Excellent point. Thank you. An independent or professional trustee is either going to be an individual, it could be an attorney or a CPA, or it could be a corporation, it could be a bank or trust company. These folks have to be paid on some kind of basis. So professional trustees, especially corporate trustees, have a fee schedule, and they have to file that fee schedule with the Department of Financial Regulation. So some people look at that and say, well, that's an advantage. It's predictable, and the fees are actually paid from the trust itself on an annual basis. There are other standards of compensation. So for example, there is statutory compensation, which is kind of similar to what I just said, but in the law, if there was no fee schedule, someone would have to be paid according to statutory compensation, which is rather low. So the disadvantage of that is it might discourage someone from being a trustee because the fees are so low that it may not be realistic. And then there's another standard of compensation called reasonable compensation. Now, that's a very broad standard. Many trusts today are drafted based on reasonable compensation. What is reasonable for a non-professional might be $50 an hour. What would be reasonable for someone else might be higher. But basically, with an independent trustee, in my opinion, you would be agreeing in advance to a fee schedule, and the fees would be predictable and be paid from the trust. Okay, let's look at, go ahead, Bill.
Oh, excuse me, I'm sorry, Steve. I just said very good, but I was also going to mention that the decision is not always a mutually exclusive type decision, and that you could have a co-trustee situation with a family member and a professional trustee working together.
That is exactly right. That might be a hybrid arrangement that we see a lot. Thank you, Bill. That's great. And then I won't continue in the interest of time to belabor some of these points, but there are differences again between independent trustees and interested trustees, and this is a counseling issue. And even if you don't know your point of view on this right now, you would have this epiphany or a series of epiphanies as you go through a counseling process. And I promise you, if you are willing to spend the time, you will get to the point where you will be able to decide whether I should use an independent trustee or whether I should use an interested trustee, or as Bill said, a hybrid arrangement between interested and independent trustees. There is risk with independent or, with interested trustees. So what if we have a person who's getting older and we haven't updated our plan, or their life has changed, or they've gotten a divorce, or they're disconnected with the beneficiary? So there are various things that we have to be concerned about successor trustee risk, I call it. And we want to make sure over time we're revisiting the plan on a reasonable basis. We don't want to be in a situation where we're revisiting plans over 20 years. We want to revisit plans on a reasonable basis every 3 years, every 5 years, depending on how old you are, or even more frequently, to make sure we're addressing the issue of trustees. Now, failure to understand means tested benefits. So let's get right into this chart. On the left-hand side, we have SSI, the person who is receiving Social Security, but it's called Supplemental Security Income. This, by its very nature, and I believe the current rate is $914 a month, this is by the very nature of it going to provide Medicaid for the beneficiary of that Social Security. If that person was disabled prior to age 22, not 26 for able, but 22, that person is considered a disabled adult child. So they will receive Social Security disability upon the parent's retirement. When that parent starts taking Social Security, they will change from an SSI recipient to a person getting SSDI. Now, this is all very confusing, but look at that middle chart. And many of you have a disabled adult child in your family, and you know that that person now receives not just Medicaid, but they receive Medicare. So this person receives SSDI, Medicare, and Medicaid. Remember, the disabled adult child receives their benefits based on your work record and not theirs. I had a client here at Elville and Associates yesterday whose hardworking disabled child is, even though he's technically a disabled adult child, he has his own work record. So he does not qualify for SSDI under his parents' work record, but many of you have a situation where your child does qualify or will qualify under your work record. That child will get an amount equal to 50% of your Social Security, and they will get 75% at your death. So this is one of the things that special needs parents, I find, they don't know. This is one of the things they don't know more than anything. They're not familiar with this disabled adult child rule. So this is something we can drill down on more. Notice on the right-hand side, this is the person I'm going to focus on Section 8 or HUD housing, a person who is receiving HUD benefits. This is its own problematic category in the sense that, and by the way, there are new HUD rules coming out if you have a loved one who lives in HUD housing, some of which is actually quite nice in places like Rockville and other places. But if you have a loved one who's in HUD housing, any distribution from a special or supplemental needs trust could cause and will cause their rent to increase. This can be handled in different ways through an ABLE account distribution to avoid the increase of rent, but this is something we have to be aware of. I'm not going to go through the resource tests and the qualification for SSI. This is just part of your materials, as well as the disability determination and definitions. I'm not going to spend our time on that because time is short here. Of course, those of you who are dealing with a loved one with special needs who gets SSI knows that the resource limit remains $2,000 for individuals, but that person can still own a house. They can still own an automobile. Now, whether they should own the house or the automobile is another subject. And most of the time, we would not have the title to real estate in the name of a person with disabilities, but sometimes that could be appropriate. But just know that even if they did have these assets, it would not disqualify them from SSI. And of course, SSI is in 2020, well, our 2023 rate is not up there, which we apologize for. It should be $914 a month. And that is because of the big inflation numbers that were put out. And SSI is to pay for food and shelter. Now, many of you understand this, and there is a concept called unearned and earned income. And to try to make sense of this as quickly as we can, we know that if you are giving your child or loved one food and shelter, and they receive SSI, meaning they live with you and they are not paying rent to you, you are providing that food and shelter, their SSI is going to be reduced by 1/3. So the most that it can be reduced, do not worry about this, the most it can be reduced is 1/3, okay? And We just have to accept that. However, if your loved one pays rent, which most of you and many of you will have that situation where they're actually paying rent, and we can provide you with a very simple rental agreement if you need one, that is going to overcome that issue, and their 1/3 reduction will not occur. So we want to take away from this slide that if our loved one on SSI makes too much money, they will eventually lose their SSI. So we have to be very careful when we look at this formula, depending on how they're making money. They're out there living their lives, they're productive, it makes them happy, and they're productive in their lives, and yet if they make too much money, they will eliminate their own SSI. So this is a tension that most of you are dealing with, and we understand that, which is why in many cases we want to use an ABLE account. If our child has too much money, we can get money out of their name and put it in an ABLE account, hopefully, if they're eligible for ABLE, and use that ABLE as a tool in many ways. So just be aware of this earned and unearned income issue.
And Steve, if I could, and
Yeah.
I'll probably, and just because of the interest of time, continue to ask questions, please, everybody, but we may not get to any more questions today. And so if we don't, we will respond sometime after the webinar today. But there's two I wanted to ask just because they're relevant to the subject that you're discussing right now. One is if the beneficiary switches from SSI to SSDI, does the $100,000 limit still apply for the ABLE account?
That's a great question. In my opinion, it would not apply. But what would that $100,000 limit would not apply, Bill? And then the maximum, which you'll have in that slideshow from Kelly Nelson, is somewhere around $550,000 that the person could have in their ABLE account. But we still have to be careful that if that person earns more than substantial gainful activity, if that person is still working, they could be deemed to be a person that's no longer disabled, even if they are a disabled adult child. But the $100,000 limit would not apply.
Okay, and the second question is, if both parents work, is it based on the first parent to retire or the second? And is there any impact if the parent defers Social Security?
That's a great question. So my experience has been it's usually the first parent. Okay, it'll be based on that. And then in my experience, which is something I could double check on if necessary, is when the second parent retires and takes Social Security, it would be adjusted upward if that parent's benefit was higher.
Got it. Yep. Very good.
All right. So again, these SSDI determinations, and here is more information about the disabled child benefit. I'm not going to spend much more time on these. Medicaid and Medicare benefits. This is a tool for you to know about. And we're going to get here into just a brief set of slides about housing. And remember, I spoke about Section 8 housing being a problem that we just have to deal with. But many of you will not be planning for HUD housing for your child. You'll be planning to leave real estate into the special needs trust for your child. Or you'll authorize your trustee to be able to buy a house for the child inside of the trust. So just know that a special needs trust can hold and own a house, and if it's appropriate, if your child can live independently. Okay, now these last several points are going to be more quick. Failure to include a trust advisory committee and trust protector. We talked about these briefly, to add flexibility to the planning. So a trust advisory committee is a provision that you can put in a special or supplemental needs trust to say, if my trustee needs advice, not just legal general advice or financial advice, but this is a real crisis that's happening. My loved one has mental health issues. We need to call a meeting of the social worker, the psychologist or psychiatrist, the caseworker. We have to get people together, and I need advice as a trustee. This is a nice provision. It's not going to be utilized in some cases, but in some cases it's very important, depending on the nature of your loved one's disability. It provides flexibility for the trustee. It's not required, but these kinds of provisions are nice to include. I know when I've served as trustee before of a special needs trust, I have needed to call a committee together of people at times to really advise because of what was happening. The trust protector is a special fiduciary that Maryland has recognized since 2014. Trust protectors have been around in the law for about 25 years now, and a trust protector provides flexibility to a trust, especially a special needs trust. This takes a little bit of getting used to for many people. It allows someone like a special fiduciary, usually an independent person, but it could be a family member in special needs planning. Because of the nature of the planning, this could be a family member that has the authority to remove and replace the trustee. So it's usually not your initial selection of trustees that we're worried about, especially if they're family members. It's usually a trustee down the road after your death, many years from now, someone that could be the trustee of the trust that we just don't know who that would be today. But anything could happen in the future. This gives you assurance that you have a special fiduciary that could remove and replace a trustee. Let's say someone refuses to serve. The trust protector can be there to remove them and replace them. The trust protector can also amend the trust. So this is important just recently with all the changes that have been occurring with the Secure Act, that the trust has a flexibility mechanism to be able to change provisions of the trust administratively or for tax purposes. So basically what we're doing here is building in flexibility. This takes a little bit of getting used to, but most special needs families will ultimately conclude that we should use a trust protector for flexibility, as well as non-special needs trusts. The trust protector, again, is a special fiduciary. They can remove and replace trustees. They can mediate disputes. They can compel an accounting. What if your trustee is not providing an accounting like they're supposed to? And what if your loved one does not have the ability to appreciate an accounting? Now this trust protector can obtain an accounting. So this is a very important thing. As we start to get towards the end of our presentation, the failure to align assets. What did I talk about initially? Well, if we have a will plan, we have two steps with that will. We have to create the will, and it may have the special needs trust in it. It may have the special needs trust sitting over here by itself, a standalone trust. But no matter where that special needs trust is, we have to take the second step in a will, which is to make sure the beneficiary designations are correct, that assets are flowing from point A to point B, wherever they're supposed to go. And this is no small thing in the post-COVID world. Simple things like beneficiary designations can go wrong, and we want to make sure that assets are properly flowing. I'm going to illustrate this in the next couple of slides. Here, we're showing how assets can flow with beneficiary designations, joint ownership, transferable on death designations, payable on death designations at the local bank. These are all ways that assets can flow from here to here, but we have to be very careful. If we look at this slide, we see that we have a will, or in the case of a revocable trust, we also have two steps. We have to create the trust, and then we have to put assets in the trust. For example, our non-retirement assets would go in the trust. But look at this slide. This slide shows that this person had a great will, or they had a great trust, but look at what happened to the assets. The assets at death passed in a way that went straight to somebody, straight to a beneficiary, and the will or trust did not control the asset. So let's say this person had a special needs child. As we go to the next slide, we see the same thing in a different way. A person has a will that creates a special needs trust, or it provides for how assets are to flow to the special needs beneficiary. But we didn't have our ducks in a row. We didn't have our assets flowing properly. So the assets actually went outside of the will, either directly to the person or directly to another person, and the trust never got funded. So what we want to make sure of is that no matter where we have the special needs trust, no matter whether we have a will or a revocable trust as our basic plan, we want to make sure the assets are going to flow properly. Arguably, how we own the assets at the time of our death is the most important thing in estate planning. So if we have a special needs trust, we want the assets to flow where they're supposed to go, or our plan will be defeated.
And Steve, just quickly, in our practice, that area is where we typically see most of the errors, and assets that have not been put into a revocable trust. We just a few years back had a case where the father had put together an excellent plan, had 2 disabled children. He also had a large IRA account, and he forgot to update the beneficiary designation. So he left the IRA outright to the 2 disabled children. He didn't leave it to their trust. And so the importance of understanding how the assets are titled and to understand what happens to that asset at your death, including making sure all your beneficiary designations on life insurance and retirement plans, is just critical.
Thank you, Bill. I couldn't agree with you more. And failure to create a memorandum of intent. We talked about this as one of the design features of a nice supplemental needs trust. So this tells the world, this is what my loved one is like. This is what they, this is how, these are the foods they like. These are their preferences. These are their needs. I've even had families with a loved one with extremely high needs create an entire manual on how to take care of their loved one. So this is a memorandum, and we're happy to send you a kind of a template that you can start to think about this and work from. But I strongly recommend that this be attached to the back of the special needs trust or supplemental needs trust. It talks about your family members and your preferences, your goals for the person, about their quality of life in the future. So whether we call this a memorandum of intent or a letter of wishes, it doesn't really matter what we call it. The thing I want to challenge you with here is to do this, because this will separate your loved one's special needs or supplemental needs trust from all others. This is the thing that customizes it to their particular needs. Now, the advisory team, I mentioned this early on. We failed to form an advisory team. This is another mistake. And Bill has talked to several points that are very important in this conversation. And I know many of you on this webinar are Bay Point Wealth clients. So I want to assure you that because you've got Bay Point, and if you don't have a financial advisor, I strongly recommend that you consider meeting Bill and Bay Point. But the big point here is to have a team, an advisory team. And I would call that team a team of your attorney, your CPA or tax preparer, and your financial advisor. Now you have a team. But having a team is not the only thing. That team needs to talk. That team needs to actually talk to one another and communicate. And this has to do with having the right team of advisors to deal with flexibility and a changing environment. So again, I strongly recommend this. And as part of that team, we talked about an advocate, having an advocate. Many of you, all of us actually, are getting older. And as we get older, if you have a special needs child, we want to make sure that you are introducing that child or your other family members to an advocate that can actually help your survivors to be able to deal with the needs of your special needs loved ones. So last night we were having a meeting with someone with a group we call the Option Group. It's a very popular group in Maryland now of life care managers. And they were telling me last night that they recognize that we have a tremendous need for advocates, that in estate planning, we need to be able to introduce special needs planning. We need to be able to introduce families to advocates that can be there for their loved ones in the future and advise the trustee. A good advocate is going to be able to do a wellness check on your loved one, make sure they're eating, make sure they're not being abused, make sure that their vital signs are good. And again, we talked about trust protectors. So having that team is very important, including the advocate. And then finally, and thank you for staying with us throughout this whole presentation, failure to understand the Secure Act. So many of you know that you have a lot of your assets in retirement plans. And President Trump signed this law in 2019, December of 2019. It's been the law ever since. It doesn't look like it's going anywhere. And it does say that 98% of the people in this country who are healthy and well will pay tax on inherited IRAs after we die, and we leave IRAs to healthy children. They're going to pay tax in 10 years or less. So Uncle Sam is accelerating taxation on trillions of dollars of retirement funds. But your special needs loved one, your loved one with disabilities, or a chronically ill person, as defined by the code, are exempt under the Secure Act. So we want to make sure that because they're exempt, when they receive those IRA assets, they are able to stretch those out into old age if the trustee does not need to use those assets for the loved one. And we want to not only make sure that we recognize that they are exempt, because they, meaning the disabled loved one or chronically ill loved one, is called an eligible designated beneficiary. That's a new class. So we want to make sure that the trust itself is an eligible designated beneficiary. And when the IRA money comes into the trust, that it can be stretched out just like it's supposed to be. So that's an important thing. And the good news is, right at the end of 2022, there were new clarifications of the Secure Act, and now it's being more and more clarified, and there are more and more favorable rules with how to treat loved ones with disabilities and the parents who are planning for them. So we're not going to go through this last slide just in the interest of time, because I've run over just a little bit, but this is a resource for you. We want you to think in terms of process when you're thinking about any kind of planning. And here in the center of this rather colorful slide, you see our planning team, and we're talking about the different aspects of the process of planning. And as we finally get to the last slide, I just want to encourage you and thank you for attending, but also just to say, we want to give you a path forward. Bill and I talked about this yesterday. We don't want to just educate. We want to just be a resource to you. We want you to look at your current documents if you have them. And we want you to have questions and write those questions down. Come talk about what your situation is. There is nothing to fear. A lot of people feel that it is a huge undertaking, and I understand, to come and talk about such things. But we want you to understand that if you do talk to an attorney about your situation, there is an attorney-client relationship established right away, even if you do not ultimately become a client. So there is this confidential relationship. There's nothing to fear. We want to help you form an advisory team if you don't have one. But the biggest thing that we find with families with loved ones with special needs is they don't have a lot of time to think. And we want to give them the space and the time to think. And I know Bill and Bay Point are very much big believers in the same thing. So with that said, I apologize. We've gone over a few minutes because of the length of the presentation. But I thank you for your time and attention. And Bill, thank you for the opportunity to present and
Yes,
wonderful questions. Thank you, everybody.
Yeah, very good. Just a couple things before we wrap. One is thanks again, everybody, for joining. And Steve, as always, excellent job, very insightful, very valuable information. So thank you so much for giving us the time today. There are a few questions we didn't get to, and we'll send emails out. There's just a couple out here. I have names on all of them except for one came in anonymous, and it had to do with the rent within maximum SSI payments. If you could send me an email, we'll get back to you to give you an answer on that. And that's it. So very good. As I mentioned, we will have a follow-up email with all of this information. It will also include Steve's contact information if you'd like to reach out to Steve. So again, thank you all so much for attending. Steve, thanks again. And I hope everyone has a great weekend, and take care. Bye-bye.